Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Be ready for the dictation without any stop. Non-stop dictation for 10 minutes. Start. In the above appeal, the order dated 17/11/2017 passed by the High Court of Punjab and Haryana in criminal revision number 4070 of 2017 and criminal revision number 4113 of 2017 are assailed. Through the said order, the High Court has dismissed the criminal revision petitions and upheld the order dated 31/10/2017 passed by the trial court summoning the appellant as an additional accused by exercising the power under Section 319 of the Criminal Procedure Code 1973 CRPC for short. For the purpose of narration of facts, the case in Criminal Appeal number 885 of 2019 is noted. The position which led to the appellant being summoned is that on 5/3/2015 a first information report was lodged in the police station Sadar Jalabad against 11 accused for the offence under sections 21, 24, 25, 27, 28, 29 and 30 of Narcotic Drugs and Psychotropic Substance Act 1985 NDPS for short, section 25A of Arms Act and section 66 of the Information Technology Act 2000 IT Act for short. In the charge sheet dated 6/9/2015, 10 accused were summoned and put to trial in Sessions Case number 289 of 2015. Though this second charge sheet was filed by the police, the same did not name the appellant herein as an accused. In the trial conducted before the learned sessions judge also, initially the name of the appellant was not mentioned by the witnesses. After the initial recording of evidence, the prosecution filed an application dated 31/7/2017 under Section 311 of CRPC for recalling PW4 and PW5, which was allowed. In the further examination of the said recalled witnesses, they named the appellant herein. The prosecution thereafter filed an application on 21/9/2017 invoking Section 319 of CRPC in the said Sessions Case number 289 of 2015 for summoning additional 5 accused, including the appellant herein. The summoning of additional accused was sought based on the evidence tendered by PW4, PW5, and PW13. It is to be noted that out of the 11 accused, the proceedings in Sessions Case number 289 of 2015 were against the 10 accused, and since one of the accused was not available, the case in that regard was split up, bifurcated, and was subsequently numbered as Sessions Case number 217 of 2019 on 3/9/2019. In in that background, it is seen that as on the date when the application under Section 319 CRPC was filed on 21/9/2017, the only proceeding pending was Sessions Case number 289 of 2015. In that regard, in respect of the proceedings against the 10 accused, the learned sessions judge pronounced the judgment on 31/10/2017, whereby one of the accused was acquitted while the remaining 9 accused were convicted, and sentence was imposed on 31/10/2017. The learned sessions judge also allowed the application filed under Section 319 of CRPC on the same day, that is 31/10/2017, and summoned the appellant to face trial. It is in that backdrop the appellant assailed the order dated 31/10/2017 summoning him to face trial, since according to him such order is not sustainable in law, as the same was not passed in a proceeding pending before the learned sessions court, as at the stage when the power to summon was exercised by learned sessions judge, the judgment of conviction and sentence had already been passed earlier on 31/10/2017. The said order assailed in revision petition number 4070 and 4113 of 2017 was dismissed by the High Court, which has led to the present proceedings. The instant petition was heard before a bench consisting of two honorable judges of this court on 10/5/2019, wherein in the course of assailing the summoning order, the decisions of this court in the case of Shashikant Singh vs. Tarkeshwar Singh 2002 5 SCC 738 and the decision in the case of Hardeep Singh vs. State of Punjab 2014 3 SCC 92 rendered in the context of the power exercisable under Section 319 of CRPC were noted. In that context, the bench of two honorable judges of this court was of the opinion that the question with regard to the actual stage at which the trial is said to have concluded is required to be authoritatively considered, since the power under Section 319 of CRPC is extraordinary in nature. In that view, the following substantial questions of law were raised for further consideration, and the matters were placed before Honorable the Chief Justice of India for constitution of a bench of appropriate strength to consider the questions raised. Honorable the Chief Justice has accordingly constituted this bench to consider the questions raised, which read as hereunder. In order to answer the above questions, we have heard Shri P.S. Patwalia, learned senior counsel for the appellant, and also Shri Puneet Singh Bindra, learned counsel, who appeared on behalf of the appellant in the tagged matter. Shri S. Nagamuthu, learned senior counsel, has assisted this court as amicus curiae. Shri Vinod Ghai, Advocate General, appeared for the state of Punjab, while Shri A.K. Prasad, learned additional Advocate General, appeared for the state of UP. Shri S.V. Raju, additional Solicitor General, has appeared for the Union of India, since a case is said to have also been registered against the appellant under the Prevention of Money Laundering Act 2002. We have also heard Shri Ashish Dikshit, learned counsel, who appeared for the Intervenor Prosecutors Association. The gist of the contention put forth by Shri P.S. Patwalia, learned senior counsel, is as hereunder. Order summoning a person appellant herein as an accused under Section 319 of CRPC was passed at a stage when the trial had already concluded and even judgment and order on sentence had been pronounced. It is contended that the said order is therefore in violation of Section 319 of CRPC and Hardeep Singh Supra, wherein in para 47 it was held that power has to be exercised before pronouncement of judgment. It can only be exercised during the pendency of the trial, which is a stage anterior to the date of pronouncement of judgment. In fact, this is also consistent with Section 353(1) of CRPC, which states that after perusal of the evidence, the judgment is to be pronounced after termination of trial, and therefore Section 319 of CRPC mandates that the power can be exercised only during trial, and it follows that once trial is concluded and judgment is pronounced, the court cannot exercise power under Section 319 of CRPC at that stage. contending that it can be simultaneous is also equally violative of Section 319 of CRPC, and the law laid down is clear that it has to be done before judgment. In a nutshell, if an accused is to be summoned, it has to be done when the trial is alive. The moment trial is concluded and the matter is kept for judgment, then the stage for exercising power under Section 319 of CRPC goes, and the court thereafter becomes functus officio.